Good evening. That's a picture of the Supreme Court from 2020 in November. And we're going to talk about fundamental rights today in a series. And I want to go back and talk about first what I did in the first of the Do Ask, Do Tell books. That the original one was published in 1997. That's what it looks like with one print run. And then it went to POD in to August of 2020. But so, and we're talking about this book, and that's the table of contents, and it's particularly chapter 6. Where I talk about a right to privacy amendment. And what I did was propose a 28th Amendment at the time that was what had been to the Constitution that would have guaranteed certain rights as fundamental rights and protected largely by substantive due process. And then I would, write another book, two other books later on that would discuss this further, which I want to talk about in another video. But I'm starting out by talking about where I was in 1997. It was released to the public on July the 11th, 1997, and with the first print run, and it sold out in about 3 years, and that's when I went to POD and with iUniverse in August of 2020. I moved to Minneapolis right after publishing the book. That was a very important time in my life. Just as a little bit of a history, chapters 1, 2, and 4 of the book, I think if I go back to the table of contents, chapters 1, 2, and 4 of the book were the original narrative chapters that I had in mind when I was going to tell the story of my connection to the gays in the military debate. Chapter 3 was added later, which was kind of my coming out a second time. And I actually had several versions of this book, and at the end I started it in 1994 after a vacation in Colorado, and when I moved into a new apartment I finished the first version where I had what are now chapters 1, 2, and 4, and then I had 10 short chapters that talked about various topics. Excuse me. And then I compressed those 10 short chapters to 4 essays, which I would send these all to a literary agent in May of 1996. The 4 essays were never published in a book. They are, I should probably just show you where they are. They are in a file on my John W. Bushka site. Talked about morality, family values, and then the workplace, and then personal autonomy. Those 4 chapters basically got compressed into chapters 5, which was family values in the workplace, and then chapter 6, which was sort of the moral foundation, and then the proposal for constitutional changes as I saw it in 1997. So one other little side note to the first printing, which the first printing, the back cover actually had a problem where I said that the Bill of Rights was at the time about 160 years old. Well, it was actually official in 1791, which would have meant even then it was a little over 200 years. It's not a very good idea to say how long how old something is on a cover of a book, because as time passes, it's going to change. But right now, I think it would be 233 years. It's just something else that I fixed on the iUniverse version. But that's just something else. There was in the book, I did mention the idea of a Bill of Rights too, and I even talked about the idea of a constitutional convention, which would be talked about more in the second book of When Liberty is Stressed Later. And there was also, and that will get me to discussing what the Bill of Rights idea really was. I proposed that there would be an Amendment 28, which would formally be called the right of privacy, intimate association, life, and pursuit of happiness. And there were 13 sections to the way I wrote it, and I think I can show you the page. Which is there, it's on page 425. The table of contents online has the page numbers from the first printing. I probably should change that, but that's what it looked like. And let's just go through what the rights were. One of them was that crimes, anything that's made into a criminal law, has to be provable, and that was certainly a weakness of sodomy laws. Normally, you couldn't prove that it had happened, and so that I thought of as a procedural due process issue. But the rest of most of these other things were about substantive due process. Harmless adult consensual conduct should be protected as substantive due process. In other words, cohabitation should be protected. There should be no need. There should be no need to create a suspect class to protect any of these rights. I suggested that abortion be protected for 90 days, or about the first 13 weeks, I think that would be. This is, again, back in 1997, and we still had Roe versus Wade on the books, but I suggested putting it in the Constitution. Civil asset forfeiture should be abolished. Involuntary servitude, this is very important, which would include military conscription, would be prohibited. That would end, of course, the draft had been ended, but that would end selective service also, registration, if that was done. Incidental prayer in public places would be protected. Parental rights regarding school curricula would be protected, and that could be very important now in the gender identity debate, if that was true. Reverse discrimination, like affirmative action by group, would be prohibited. We sort of wanted, meritocracy and equal quality of opportunity, but not necessarily equality of results. In other words, equity by group. We wanted equality by individual. There was a provision that internet content, that this was an answer to the earlier Communications Decency Act that had been struck down, although Section 230 was kept, that you couldn't prohibit speech as long as there was some provision to allow verification of age. I had proposed that as in this amendment. That later literally became the Child Online Protection Act, which turned out to be flawed and would have severely restricted the internet a lot more than we first thought. It was sort of the follow-up on the original Communications Decency Act, which was quite restrictive. And that would be overturned in 2007. And then there would be procedural due process in the military, which was essentially to protect the private lives of service members when they were off base and off duty and not deployed, so that would basically protect gay service members. That was one of the ideas of the way I wanted to end the ban at the time. There was no mention of the Second Amendment in this list, which is, at the time, There probably should have been. It was in 2008. There was a decision, District of Columbia versus Heller, that sort of made ownership of firearms an individual right rather than belonging to a militia. So I didn't really consider that. And then the ideas of procedural versus substantive due process, are talked about. And remember that there's sort of a discussion of it that I'll give you a reference to here. I really should have preset this. And the Constitution Center has a discussion of a very detailed explanation of procedural and substantive due process as they are interpreted from the 14th Amendment, and also the incorporation doctrine, which applies some of the provisions to states, but not always, and that's a fairly complicated topic. Procedural, and there's also a Wikipedia reference that explains what substantive due process is. Kind of having trouble with getting this. I wanted to bring this up. I should have preset this also. Substantive due process, which is also defined in Wikipedia. And here's their fundraising thing. What Wikipedia explains is a principle in constitutional law that protects what they call fundamental rights, even if they're not enumerated. That's somewhat related to the 9th and 10th Amendments, but also the 14th Amendment. Sometimes it's called substantive due process is called the fairness concept. The laws against, the 1962 Griswold versus Connecticut decision on contraception. And then later on, eventually, Lawrence versus Texas was basically on substantive due process. So that's a very important concept versus procedural. And that's the concept that Alito, particularly, and Thomas questioned when they overturned Roe versus Wade in the spring of 2022. So I thought I would mention that. And just one other thing, there was also in the book a proposal for a 29th Amendment, which would have dealt with gay marriage, but that's obsolete because of Obergefell in 2015. But remember, this was 20 years before, almost 20 years before, when the Defense of Marriage Act had been passed and signed by Bill Clinton. It's also important to note that when the 1997 book was published, that President Clinton had protected security clearances for gay civilians in 1995, and but Don't Ask, Don't Tell was still in place. It wouldn't be repealed until 2011. So that's pretty much what I have, and I do thank you for listening. It looks like the picture, my camera went off.